Assalamu alaikum wa rahmatullahi wa barakatuh. The show that converts legal jargon into legal ease. And tonight I'm joined by Advocate Mohamed Feroz Dollie, and we're talking about the Muslim Mediation Arbitration Council, an initiative that was founded in 2001 as a result of certain initiatives taken by the ulama and attorneys in order to try and address the need for mediation and arbitration, primarily for the Muslim community, but not specifically and only for them.
That were involved in dispute resolution at the time, to set up a body in anticipation of the Muslim Personal Law Bill coming into effect and establish some sort of footprint regarding the resolution of disputes. Now those disputes would be, the purpose of that would be in order to create a profile. So when the Muslim Personal Law Bill eventually came into existence, the MMAC would have had a footprint, would have been credible, would have had resolved disputes, and would have been seen as the natural approach, or there would have been a natural approach to the MMAC to resolve disputes. Okay. That was the thinking around that. So what happened then was that an open invitation was sent out to as many lawyers as possible. That open invitation was in order to, was mooted to invite the lawyers to sit down with the ulama and talk about the creation of the MMAC. It was very well attended. I mean, the meetings were held in Fordsburg at the time. It was unanimously resolved, though not formally resolved. It was unanimously resolved to set up a trust. And in order to get the body going in some sort of format, and the vehicle that was used was a trust. So once the trust was registered, the next step would then have been to follow up on the processes. But so essentially, the profile of the organization was to try and get a dispute resolution body running. It was noted at the time, and I think it is still being noted, that the Jamiats and some of the Muslim organizations play a very important role in dispute resolution. But the process of the MMAC would be to try and formalize those processes in order to get the parties to accept that this has some sort of legal binding role to play in the resolution of disputes.
So historically then, you had a number of ulama and lawyers getting together to form the MMAC.
Indeed.
Did they undergo any specific or special training?
Yes, no. Once the body was established, there were lots of policy discussions regarding how it should be run, who gets admitted as panelists onto this, in order to have them resolve disputes. And so once the panelists were then, or once these discussions were held, the panelists were invited, or they had applied, and they had to go, and they had to undergo some sort of training. Mediators, it was my experience and the experience of those who had taught me as well, that we needed to be trained on dispute resolution. And the processes of training were then undertaken in order to get the parties or the panelists to become familiar with the processes of mediation and arbitration. And for the secular panelists, specifically the lawyers, there would have been a very short introduction to some Sharia courses to get them familiar with the principles of Sharia, depending on the natures of the disputes that they were going to be resolving. So there was extensive training that was done. The training was primarily conducted on mediation and arbitration. One of the trainers was one of your previous guests, Professor Raja, and the late Mohamed Jajbai, who did mediation and arbitration training for panelists both in Gauteng as well as in the KZN province. It was also mooted that the MMAC would have a national footprint. Unfortunately, it hasn't yet reached that stage, but we're hoping to get there soon.
Now, does the MMAC enjoy any jurisdiction, or are there any jurisdictional issues regarding the MMAC?
Well, I think it's important to keep in mind that the MMAC is a dispute resolution body which the parties will approach voluntarily. It doesn't have any jurisdiction over parties to drag them to these processes kicking and screaming. Unlike in a court process. A court is is established, you can summons a party to appear before a court. If they don't, the matter can go in default, and that judgment against a party who doesn't appear has or can be enforced. The MMAC doesn't have that kind of authority over the parties. What they have to do is they've got to go to the MMAC voluntarily,
right?
Or if one of the parties approach the MMAC, the administrator of the MMAC will forward the complaint on to the respondent, who is the other party in the process, and determine whether the respondent would be willing to come to the MMAC to resolve the dispute. Okay.
So, with regard to jurisdiction itself, what if the parties agree prior to the dispute, like they enter into a contract and they write in a clause that says, in the event of an arbitration or mediation, we hereby choose the MMAC to be the forum. Does that foster jurisdiction onto the parties?
Well, yes, of course, because what you're doing is you're agreeing up front to the preferred dispute resolution process that you're going to be following.
Right.
I've heard some of your panelists also refer to this as appropriate dispute resolution.
Right.
Because instead of going to a court, we know that the courts are backlogged.
Yes.
There are a lot of formal processes that must be followed. The accessibility of the court by a layman is possible, but not something that is encouraged. They would rather have the court process accessed through the use of lawyers.
Right.
Okay. So the parties can decide up front, and if they understand the process of mediation and they understand the processes of arbitration and how that works, and understand how to access these processes, what they can do is, long before a dispute arises, they can write into their contracts that in the event of a dispute, and it's just something that it becomes a preventative measure in a contract, that you would get the parties comfortable with these processes, and they would then say, in the event of a dispute, let's go to mediation, let's go to arbitration, rather than going to a court. Okay.
No, but doesn't that affect the independence, or what is the independence, or what kind of independence can applicants and respondents or parties expect from the MMAC?
Well, I think this is a very important question, simply because what we need to consider is that the MMAC has to be independent and must be seen to be independent as well. Now, at the time that the MMAC was established, it was established through the trusteeship of a number of lawyers, of 7 lawyers and 7 ulama, with a number of founding members.
Right.
It has to be seen to be independent. It cannot be under the control of any organization or under the control of any specific patronage.
Right.
Okay. So what you would try and ensure is that the MMAC is an independent functioning or independently functioning body that would assist the parties to resolve the dispute. It finds its independence in the manner in which it is run, and how parties will approach it for dispute resolution. So I think what you also need to keep in mind is and I think the independence leads to the issue of financing. Is that how does the MMAC fund its
funding? Yes,
fund
that's
its
very
activities.
important. Yeah,
and I think it's and I think you should keep in mind that it's very important that that the bills be paid.
Yes.
Okay. So what they would do is that they would fund the process of mediation and arbitration from the panelist fees that would be charged. Okay. Now let's just talk a little bit about access to the MMAC in order to then get to the process of funding.
Before we go to access, I think it's just time for a short break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight I'm joined by Advocate Mohamed Feroz Dollie, and we're talking about the Muslim Mediation Arbitration Council, an initiative that was founded in 2001 as a result of certain initiatives taken by the ulama and attorneys in order to try and address the need for mediation and arbitration, primarily for the Muslim community, but not specifically and only for them. Now, we've heard about the history and the jurisdictional elements as well as the independence that the body enjoys. And particularly on the point of independence was the funding of the MMAC. With that goes a very important aspect of trust, and because trust is part of independence, you have to be seen to be independent.
Well, I think it's important that you consider what parties or what faith parties are placing into the mediation process and into the arbitration process. And they want some sort of security.
Right.
I think we need to understand that if parties don't feel secure about coming to you, then there would be
a question mark on impartiality, on the judgment, and all of those issues.
Indeed.
Now, just before we carry on, the lines would be open and are open, and the reminder is that you can call in with any question that you may have on the MMAC. And the number, as usual, is 011-086770012 or 3. Please call in if you have any questions for Advocate Mohamed Feroz Dollie. With regard to the actual process now, what process, how does one go about engaging with the MMAC? If I have a dispute with you, what do I do?
Well, let's talk about the ideal situation.
Okay.
The situation in which two parties would come to the MMAC together, they would either agree through their representatives or they sit down and agree with each other that they need to get assistance in resolving a dispute. What they would do is they would approach the MMAC together.
So you don't need lawyers. I mean, let's just be clear. You don't need a lawyer to approach the MMAC.
No,
individuals can do that.
Absolutely,
right.
Absolutely. And I think it's encouraged that parties maintain ownership of their own disputes.
Right.
And find ways of resolving it in order to resolve their disputes, but I think also importantly is to maintain their relationships.
Right.
Okay. I'm not suggesting that lawyers damage relationships between parties.
Not
either.
at all. I mean,
okay.
I think they quite the contrary.
Of course, of course. But so what you would do is you'd approach the MMAC, complete what we call is a referral document where you need to note your details down.
Right.
You need to note down the details of the other party whom you are in dispute with.
Yes.
And a brief issue or a brief description of the issue in dispute. Now, if you do not approach the MMAC jointly, what you would then do is you'd approach the MMAC on your own.
Right.
And you would now be regarded as an applicant.
Right.
The other party in the dispute would be regarded as the respondent.
Right.
So the applicant comes to the MMAC, you refer a dispute, the administrator would receive it and would transmit that to one of the other, the other respondent in the matter.
Right.
Then determine from the respondent whether he or she would be willing to come to the MMAC to resolve their dispute.
Okay.
Remember what we spoke about jurisdiction?
Yes.
And jurisdiction said that the parties come there by agreement.
Yeah.
If the respondent is amenable to approaching the MMAC in order to assist to resolve the issue that has arisen, they would then jointly choose a panelist.
Right.
Now, depending on the level of expertise of the panelist, they'll do some research regarding the panelists, their training, what their levels of expertise are.
Will they Google the panelists?
And what their fields of expertise are. I'm certain that some of the panelists would be able to be Googled.
Right.
I'm not certain if all of the panelists are subject to providing enough information through Google. But what they can do is they could ask the administrator of the MMAC for a list of the panelists that are on the panel and who are available.
Now, with respect to this recent court-assisted mediation process that seems to be becoming more and more popular, panelists could be specifically skilled. Like if it's a construction dispute, for example, you could ask for a panelist with that experience.
Yes.
Now, what about if the parties say, look, I only want the Sharia to apply. I don't want no secular law here. Is that possible?
Of course.
Right.
Look, you are entitled to approach the Muslim Mediation Arbitration Council on the basis of your freedom of religion to use the law that you would like to have applicable.
Okay.
As long
I'll
as
ask you to just pause there, please. We have a caller. Caller, please go ahead. Hello, can you hear us? Caller? Seem to be having a problem with that line. Sorry, you were saying?
Okay, so what they would do is they would approach the MMAC on the basis of saying, I would like my dispute resolved in terms of Sharia law.
Yes.
Okay. You have a constitutionally protected freedom of religion.
Right.
Provided that what you are asking the MMAC to do doesn't fall outside of their jurisdiction.
Yes.
Now, all criminal matters can't go to the MMAC at all.
Okay.
It has to go to the prosecuting authorities.
Right.
They would have, the prosecutors would make a decision as to whether they want to prosecute a matter or not. You also cannot approach the MMAC on a status matter at arbitration. However, through the family advocate, you can mediate a dispute, and if the family advocate is satisfied, the agreement can go to court and it can be made an order of court. So you're not interfering with the role and the status of the courts as the upper guardian.
Yes.
Okay. I mean, that's obviously something that you don't want to do. But let's say you have a commercial dispute and you want your commercial dispute to be resolved in terms of the application of the Sharia.
Right.
Something that I think maybe is, actually rings truer is to have an inheritance dispute resolved in terms of Sharia.
Right.
So what you would then do is you'd come to the MMAC, ask for your dispute to be resolved in terms of Sharia. Those are the principles that would be followed.
Yeah.
And your panelist, who could very well be an alim, right, would be able to assist you, who has the necessary expertise, who has been trained as a mediator or an arbitrator,
right,
and who will be able to assist through the use of Sharia law to resolve your dispute.
So I think the one thing that the public can be very well assured about is that both the mediation arbitration processes have highly qualified people to deal with it. It's a specific skill. It's not like, you're walking in and you're taking a chance in this mediation arbitration. That the role of the mediator is very specific. I mean, he's skilled to deal with these things. What is the how is the process unfolded there?
Okay, let me just take a step back.
Yes.
And let me talk talk to what is required of a mediator and arbitrator during
the specific
during
skills.
the process,
Okay.
and some of the specific skills that they require. Now, I think mediation is bandied about.
Yeah.
People use the word mediation loosely.
Right.
And sometimes the context of explaining what mediation is and what it means is misunderstood.
Okay.
So what I think we need to do is to ensure that if you're going for a mediation, that you find a panelist who has been trained, somebody who you would probably make inquiries about to find out how he's fared as a mediator in the past, and you can sort of create an expectation of how he's going to fare in the future.
Right. Is that because arbitration is actually binding? Is that the nub of it? Because look, mediation is a process that is guided by the mediator.
Indeed. And
let the parties deal or try and find the best possible solution. But arbitration is almost like a judgment, is that right?
Well, indeed. The arbitration at the MMAC is conducted under the Arbitration Act, which is an Act of Parliament. It's Act 42 of 1956, I think. Oh, sorry, 1965, 65. I apologize. Now, an arbitration becomes a final and binding award upon the parties. Let's just go back to mediation again. When parties use mediation, or they use the term mediation loosely without understanding the process well, a mediator who hasn't been properly trained, can misguide the parties during the process. I think it's very important. Yeah, of course it is. It is very serious. Because what you're aiming to do in the mediation process is to have the parties come to the process, resolve their disputes, but more importantly than that, also maintain their relationships.
I think that's the nub of it.
Indeed.
Is that I think the mediation process ensures that the parties are able to still talk to each other after the event or the dispute.
Well, that would probably be a measure of success of the mediation. When, where the parties leave with the ability of still continuing their own personal relationships beyond the mediation. Now, unlike an arbitration or unlike a court judgment, there's a winner and a loser.
Yes.
One of the parties walks out of this kicking and screaming or crying,
Yeah.
And the other one, he walks out with his hands in the air, lifted, and he's happy.
Yeah.
I mean, that is just the process that the parties have
litigation is acrimonious. It's adversarial. Somebody's going to win, somebody's going to lose.
Right.
With mediation, there's a fair chance that the relationship could survive, because you try to find a meeting point, isn't it?
Well, not only you try and find a meeting point,
yeah,
you try and get the parties to resolve the dispute so that dispute never comes back to haunt them again.
Now, let's talk about that, specifically with regard to some of the estate matters that you've been dealing with.
Okay.
Just typically, disputes regarding estates could go on for generations sometimes.
Well, indeed they do, and I think that's maybe one of the problems that we have, despite the fact that we have a Quranic injunction that guides guides our inheritance. We don't always follow it to the letter.
Right.
And that can lead to acrimony down the line. And, people have a tendency to talk.
Yes.
I will talk to my children about what happened in my father's estate, or I will talk to my grandchildren about what happened.
Yes.
And that conflict and that tension tends to filter from generation to generation.
Absolutely. I think just on that point, it's time to take another break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. We have a call on the line. Caller, please go ahead.
Assalamu alaikum wa rahmatullahi wa barakatuh. My name is Aziz Kathrada. I'd just like to pose a question.
I'm sorry, caller, I can't hear you. There seems to be a problem with the sound coming through. I'll ask you to please bear with us. Okay, let's try that again.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullah.
My name is Aziz Kathrada. I would just like to pose a question to Advocate Dollie in respect of a contract in terms of which the parties agree to refer the matter to mediation by the MMAC, and subsequent to that, in the agreement itself, it says that any party is still entitled to take the matter further, to probably take it on review. What happens in that instance if the agreement makes provision for the matter to be taken on review?
Let's see if we've captured the question correctly.
Will it then be referred ordinarily to the High Court?
Okay. If I need to repeat your question, so his question is, the parties agreed to mediation and arbitration, and they take it to the MMAC. Are the parties or one of the parties entitled to take it on review to the High Court?
Okay. I think it's important to understand the ambit of mediation. Mediation is the parties getting together in order to try and resolve the dispute with the assistance of an independent third party. If the dispute is not resolved, it brings the matter to an end there and then. There is no right of review regarding the conduct of the mediator.
Right.
I think there is a formal notice can be given to the court that the parties have attempted to resolve the dispute.
Right.
Something that has come up in the Brownlee case,
yes,
and I think has been spoken about quite extensively,
right,
is that if the parties had attempted to resolve the dispute through mediation, they would probably have settled the matter long before it got to court.
Right.
The litigation costs far outstripped the actual judgment of the matter, and it was worthwhile exploring other options.
Right.
Now let's jump over then to arbitration, and let's answer the caller's question. In that, should the parties feel that the arbitrator has misconducted himself in some way or the other? Now remember, it's not the judgment that is being questioned. It's the conduct of the arbitrator. That arbitration award can be taken on review for the conduct of the arbitrator to be tested to ensure that he has properly conducted the matter, that he's listened to all the evidence, that he's made a rational finding, or that the finding that he has made is based on the evidence that he's heard and not anything else. Now, that would be a grounds for review that you would take it to a court. Other than that, if you have no questions regarding the conduct of the arbitrator, at that point, you must understand that arbitration is final and binding.
Okay.
It cannot automatically be appealed. And I think maybe that's where the call is coming from.
Okay.
It doesn't, you don't have an automatic right.
One needs to just clear up this fundamental fact. The fact that it's the MMAC doesn't mean it can be treated differently as an arbitration mediation body. So the same rules that apply to all other arbitration and mediation bodies would apply here.
Indeed.
Which is what you're saying. Only in the event of a personal failure by the arbitrator can that be reviewed. So something in him was lacking. He was impartial, he was biased, or he was partial. I hope that answered your question. We have Ayub on the line. Ayub, please go ahead.
Assalamu alaikum.
Wa alaikum salam wa rahmatullah. Can you hear now?
Yeah, I can hear you. I just want to set two questions, please, man. The first question, if I was divorced about 4 years ago, and...
Ayub, sorry, I just need you to bear with me. I'm going to repeat your question for the purposes of Advocate Dollie because we're having some sound problems. So the first one is that you were divorced 4 years ago.
Yes.
Right.
Now, the agreement was drawn up by her lawyer that she will pay maintenance, okay?
Yes. Agreement was drawn regarding maintenance.
Yeah. Now, the kids are with me, and according to that, she hasn't fulfilled that contract. Means she hasn't paid maintenance for, I would say, the last 4 years.
So the respondent was ordered to pay maintenance for the children who are with you, and she's failed to do so.
Yes. Now, I want to know the reason. What do I do? Do I go to the MMAC, or can I go back to her lawyer, or do I go directly to the judge?
So your question is, do you go to the MMAC, back to her lawyer, or back to court?
Yeah, and tell them that it's like a breach of contract.
Okay, thank you for that question.
That's the first part of it. The second part, if I come to the MMCA, what do you guys charge? What's your charges for handling a case like this?
Part 2 is what are the charges of the MMAC? Thank you for your call. Feroz, you got the question.
Yes, I did. Thank you. Look, what you have is an agreement which is enforceable.
Right.
What I would suggest that you do is that before you approach the courts through the lawyers, try and get the parties to a table at the MMAC and see what the problems are.
Right.
Try and determine whether there's an inability to pay or there's an unwillingness to pay. I think these are two aspects that have to be properly covered.
Yes.
Before you run off to the courtroom and say, I'd like this agreement enforced, and I insist that she pay, knowing full well that she may not be able to do so.
So, I mean, specifically on that, isn't divorce mediation that's necessary in terms of the act now? I mean, when there's a divorce, you have to go. In his case, there's already a court order. What you're suggesting, as we were talking about the earlier case regarding the estates, is no matter that the event has passed, you can still visit it with mediation.
Absolutely.
I think that's very important to understand.
I think there's nothing that prevents you from doing this. Mm-hmm. Firstly, I think you need to keep that in mind.
Right.
Secondly, maintenance will be paid for the children.
Right.
So keep in mind that there are parties who are affected by your agreement, which are not parties to the dispute.
Yeah.
I mean, these are the children. So what I think you need to do is you need to consider how you re-establish the relationship with your ex-wife.
Right. Yes.
In order to find a solution that will be lasting.
Right.
And that you will not revisit to your children at some later stage of their lives.
Right.
So approach the MMAC. Say, I've got an agreement. What I'd like to do is I'd like to find out precisely what the reasons are as to why this agreement is not being complied with. Have the other party brought to the table, and in the presence of a mediator, sit down and try and resolve the issues.
Right.
Hear them out. Very importantly, hear them out in that process, and try and then find a solution that will be more acceptable to both parties.
Okay.
Right. Now, if that is not accomplished, then you do have the fallback position of going off to her lawyer, demanding enforcement, and then possibly going off to the courts in order to try and ensure that that the maintenance is paid. So what I'm saying is that, and I think this is a classical example of where a dispute has arisen. It is now post the dispute phase. But keeping in mind the relationships of the parties that you'd like to maintain.
Yes.
And try and find a solution that will be workable.
Right.
Okay. There's a
part 2.
There's a very nice adage to that.
Yes.
is that your marriage may not have been a success.
Right.
But don't make your divorce a failure as well.
That's very good, very well put.
Thanks.
I think the second part of the question was equally important. What does it cost? Is it an expensive exercise?
Well, I think you need to weigh up costs versus the benefits.
Right.
And you need to look at all of the other associated costs with enforcing an award or a dispute.
And maybe give us a synopsis, like a difference between litigation, arbitration, mediation.
Well,
litigation by far is the most expensive.
Possibly because of the costs that are incurred as a result of legal fees.
Right.
And also what you have to consider is the time it takes in order to bring a dispute to resolution through the litigation process, and given the backlogs that are experienced in court.
Right.
So you need to weigh up your costs versus your benefits here.
Right.
Right. Going to the MMAC means that you have to refer a dispute, and there's a nominal fee to be paid. If it's 150 Rand or 200 Rand, I'm not even too sure what the exact figure is.
Right.
But it's not a fortune of money.
Right.
And that usually would cover the postage of and the costs of the MMAC in order to try and facilitate getting the parties together. Okay.
So the admin costs are very low.
They are very low.
Right.
But what you would have to incur is the cost for the panelist itself.
Right.
Or the panelist himself or herself, rather. Now, what you would pay is a fee toward the panelist.
Right.
Now, the MMAC funds its funds its operations from the fees of the panelist.
Okay.
So what it would do, it would recover a percentage of the fees from the panelist, and add a percentage onto the panelist's fee to be recovered from the parties.
Right.
And that's how it funds itself.
Okay.
I mean,
it really needs
can't
funding.
Accept, of course.
There's premises, there's recording equipment.
Indeed.
There's the panelists taking time off, and there's admin staff. So do you have an indication of fees, or should the caller just call the MMAC and find out?
Look, what I would suggest that you do is that you call the MMAC, which can be accessed through the Jamiat offices in Johannesburg.
Do you have a number?
011.
Please make a note. 011
373
373
8000.
8000. That's an easy number.
Easy number. Right? Phone. Ask the receptionist to speak to any person from the MMAC.
Right.
And you can then find out exactly what the fees of the panelists are in order to get an indication as to what it will cost in order to resolve the dispute.
Okay. I'll ask you to pause there. This is another short break that we're going to. Please stay tuned.
Okay. Thanks, Ashraf.
Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to the last section of Legal Ease for tonight. This is the show that converts legal jargon into legal ease. You will recall that we're talking about the establishment and functioning of the Muslim Mediation and Arbitration Council, and joining me tonight is Advocate Mohamed Feroz Dollie, who is a trustee and a founding member of that council. Now, just prior to the break, we were talking about estate disputes that have gone on for many, many generations. And we also heard that it's always possible to revisit old disputes via the offices of the MMAC, utilizing the mediation process. Mohamed Feroz, what specifically is your experience regarding these old estate disputes?
Well, I think two things are coming forth. The one thing is that there seems to be fractures in the family relationships that would center around the manner in which disputes were addressed, or the estate was addressed many, many years ago.
Right.
And I think it's sometimes sad to see that the parties would not even greet each other, would not even talk to each other. And I think it's something that needs to be addressed. And the MMAC then lends itself to resolving those family relationships, as well as the issues in dispute between them, and that is, the simple money matters that have to be addressed.
Yeah.
And I think another complication about, that would have to be addressed, which you can address through mediation, which is sometimes more difficult to address through arbitration, and that is the unraveling of the financial issues.
Right.
Estates may have grown, values of estates may actually be in dispute. Heirs and beneficiaries of certain estates may have now passed on, which means that their heirs become embroiled in estate disputes of their grandparents, essentially. So these are all of the kinds of issues that have to be addressed during these during these processes.
Right.
And this is something mediation lends itself to.
Right.
Now, arbitration is a little bit more difficult.
Okay.
Because what you simply have to do is listen to the evidence and make a determination.
Right.
You can't address the relationships between the parties. Sometimes in mediation you can possibly ask parties to forgive.
Right.
And see whether there is a willingness for them to do that in order to save the relationships, and to ensure that this kind of acrimony doesn't tend to fester from one generation to the next. This is the miracle work in mediation.
Right.
That I really think parties should consider.
So there is a process that a mediator. We spoke about this briefly earlier on. It's not just thumbs up. It's a very deliberate process that the mediator goes through because he's trained to deal with this.
Indeed.
Just help us understand what is that process, the role of the mediator.
Well, accessing the Muslim Mediation Arbitration Council through mediation requires that you enter into a formal agreement.
Okay.
That agreement would identify the parties in the dispute,
right?
The actual issue and the nature of the dispute that the parties are wanting to have resolved. Importantly, the choice and the appointment of the mediator.
Right.
Choose somebody who you have some sort of confidence in.
Yeah.
Do some research. Find the party find the mediator that you're most comfortable with.
Yeah.
The costs of the mediation.
Right.
And whether you would be, whether you'd consider representation at the mediation or not, and whether there are any documents that you'd like the mediator to see.
By representation, you mean can they come with their lawyers?
Of course.
Yes. Okay.
Nothing stops the parties from coming to the MMAC with their lawyers.
Right.
Remember, it's the panelist who controls the process.
Right.
Rather than the parties.
Right.
And lawyers are there to advise the parties regarding their rights.
Right.
And I think sometimes the lawyers can help the process along.
Yes.
Because they can talk to parties in a language that they understand.
Okay.
Now, also what we need to keep in mind is that parties are disempowered by the fact that they cannot resolve the disputes on their own.
Yes.
Placing your faith in a mediator may sometimes be tentative.
Right.
Parties are not willing to do that.
Yes.
So when they come with their lawyers, they feel a little bit more secure.
Right.
Because this is somebody that they trust, that they've had a relationship with, that they've, somebody who's listened to them, who has spent extensive time with them in consultation.
But let's make it clear. The lawyers themselves don't now step in and represent their clients.
No,
that is absolutely not allowed.
Well, I wouldn't say not allowed, but they wouldn't be representing their
It's counterproductive in the sense that
yes.
lawyers will put up legal, issues.
Yeah.
I think it's very clear to understand that mediation doesn't follow the laws of evidence and the legal makeup that normally surrounds a matter.
Well, I think parties or the viewers must keep this in mind.
Right.
And that is that, one, your mediator doesn't make a finding for you.
Right.
He simply assists you in determining the issues.
Yeah.
He reality tests. He uses all of the tools at his advantage.
Right.
To try and understand the dispute with you and to then assist you into getting to a solution.
Mm-hmm.
So the parties would put issues on the table.
Yeah.
The mediator would address those issues and find a solution to them.
Okay.
Okay. So keep in mind, the mediator doesn't make a decision.
Doesn't make a decision, right?
Right. Secondly, you don't have to present evidence at mediation. You're not,
right.
you're not required to be cross-examined.
Okay.
You don't have to take an oath.
Very
you just
important.
have to go there and tell the truth.
Right.
And if you have any documents to support your case, to have it ready at the process, I think it is helpful.
Yes.
So that the parties can see more or less where the dispute is going.
Right.
If you have documents to support your case. Okay. So what you would then do is you'd enter into the mediation agreement and you'd cover the issues that I have now recorded.
Right.
I think what is important to consider is the fact that mediation is off the record. Without prejudice.
Yes.
You enter into the process. If you don't resolve if you don't resolve your dispute,
you lose nothing.
You lose nothing.
Yeah.
And you go back to the point that you had started off with at the commencement of the mediation.
Right.
There is absolutely no risk to the parties in mediation whatsoever.
I think perhaps in a big sense we are informed by the legal process only by what we see on TV and watch in movies, which is usually a courtroom, adversarial approaches. And most people don't realize that, look, mediation is probably the most natural form of dispute resolution. It has always been used.
It has always been used.
Yes.
What is fascinating is that parties have now been introduced to mediation and misunderstand it.
Yes.
Go to the process comfortable.
Right.
Express yourself.
But
Talk
it's
to the
becoming a
mediator.
reality because
Talk to the
the
mediator.
court-assisted mediation process has now been, it's actually in place in Gauteng.
Indeed,
It's
of course.
a reality.
But I think what you need to do is you need to keep in mind
Yes.
that when you go to the mediation process, approach it with an open mind.
Right.
Make your presentations to the mediator.
Right.
And allow him to guide you and take you through the process.
Correct.
That gives you the opportunity to get it off your chest. I think
Very
sometimes
good.
parties just require that moment where they are, where they need to vent.
Right.
Now, you don't always get those opportunities in court.
Right.
In court, you're subject to questioning by your lawyer,
Yes.
cross-examination by the other lawyer, and there may be things that you want to say that you're not going to get a chance to say.
Also, the whole courtroom situation, the way the courtroom is set up, is the magistrate or the judge or judicial officer sits higher than everyone else.
Indeed.
It's quite intimidating. Then the parties are separate with their legal teams, and depending on whether it's a civil or criminal case, there's a specific space for you to stand in court, all alone in a box, and you're now subject to a whole lot of questions, some of which are very difficult for you to deal with.
Well, understand is that parties are not familiar with courtrooms.
Right.
These are not rooms that they see.
Yes.
Mediations and arbitrations takes place in an ordinary boardroom.
Right.
Now, it's a table, a few chairs around it, the parties are relaxed, the atmosphere is a little bit more relaxed than a courtroom. In an arbitration, you must understand that there is the evidence to be presented.
Yes.
So the atmosphere is a little bit tense sometimes, depending on how the arbitrator manages to settle the parties down, tell them what it is that they require. And often what we see is that once the parties start talking, they're relaxed.
I
they
think
calm
very
down.
important to also point out that it sometimes is beneficial to keep the parties physically separate in different rooms leading up to mediation. And the parties involved in mediation can ask for a break to go and caucus, to go.
Yes.
It's an opportunity you don't get when you're litigating.
Well, let's keep the two processes separate.
Yeah.
In mediation,
Yes.
you can separate the parties,
Yes.
talk to them in side meeting, allow them to caucus. At arbitration, you have the parties sitting around a table.
Right.
But at any time
Yes.
that they need to caucus, at any time that they need to consult with their legal representatives,
Right.
they're entitled to do so, provided
Yes.
that a party is not giving evidence, or a witness is not giving evidence. He's
Right.
not allowed to be part of that caucus
Yes.
or that particular discussion with the
Right.
lawyers. Right. So, but it's a little bit more relaxed.
Right.
Now, let's just quickly talk about the arbitration agreement,
Okay.
which is slightly different from the mediation agreement.
Right.
The arbitration agreement, similar to the mediation agreement, is you'll have the parties identified, the nature of the dispute, the appointment and choice of arbitrator, which I think is very important.
Right.
That the parties sign a document clearly identifying who their arbitrator is.
Okay.
And then the issues that the arbitrator would be required to determine.
Okay.
And I think this is different from the mediation agreement,
Right.
where you simply have to identify the issues in dispute between the parties.
Okay.
Here you're giving the arbitrator what we call his terms of reference.
Right.
Now, those terms of reference become binding.
Okay, that's very important.
Absolutely. He cannot act outside of those terms of reference.
Just give a practical example.
Let's say we are in a dismissal dispute.
Right.
An area of the law that I'm familiar with. Right? And we tell the arbitrator that he has to listen to the evidence and he has to make a finding as to whether the dispute or the dismissal is substantively fair or
Right.
not. We confine him to that particular area of the dispute and nothing else.
Yes.
Now, let's say he makes a determination on the procedural aspects of the dispute.
Right.
He's gone outside of his terms of reference. That would render his award subject to being reviewed.
Okay.
Right.
That's a good example
Okay.
of where a arbitrator has gone outside
his terms.
and what the consequences of that.
And what the consequences of that would be. Because that would take the parties right back to the start of the dispute.
Right.
So it's very important that the arbitrators maintain
Yes.
within their terms of reference. That
I
they
think it's very
don't- they
important
don't
that the parties
change.
define that term of reference.
Well, what I think the parties can do, and especially when they are lay parties,
Yes.
is to approach the MMAC.
Yes.
Once you've chosen your arbitrator,
Yeah.
what you can do is have what we call a pre-arbitration agreement with him. The pre-arbitration
Yeah.
agreement, or the pre-arbitration meeting rather, would be to sit down and discuss with the arbitrator what the issues in dispute are. That would then give the arbitrator a sense of what it is that he needs to determine. What he can then do with the parties, or jointly with them, is define the issues and define the powers that he wants the parties to clothe him with.
Okay.
Right. You can do that before the arbitration.
Right.
So when you get to the arbitration, you know precisely what the arbitrator is going to do.
Right.
You know precisely what it is that he has to determine.
Mm-hmm.
You know what your risks are in respect of the outcome,
Mm-hmm.
and you know exactly where you're going. So that's very different from mediation. Right. Then the second thing is you can talk about recording of the arbitration process. You can talk about the exchange of documents, when parties must disclose documents before the time, which I think is important. And you can talk about the number of witnesses that are going to be presented. Because what you need to do is you need to work around some of the logistics of arbitration. Okay. And the logistics require that you set aside a certain amount of days, that you have a venue that is suitable, that is big enough, that there's proper recording facilities. And those are the kinds of issues that arbitrators will assist you with when you approach the MMAC. Because what they will do is they will ensure that if you approach them, it's done in terms of an arbitration agreement. Okay. And that is what will go there.
Well, we've come to an end of another episode. Unfortunately, we've run out of time. I just have a few seconds to thank the viewers and my guest, Advocate Mohamed Feroz Dollie, and to remind you, the viewers, that you should take advantage of the MMAC. You have a very able advocate here who's explained the process. If you have any further information, you can always get in touch with the MMAC. Mohamed Feroz, thank you very much for attending tonight.
Ashraf, it's truly been a pleasure. The time has flown. I think there's so much more to talk about.
Absolutely.
But I hope the viewers have benefited from this short presentation. And let's try and keep as many disputes out of the courts as possible.
And on that happy note, we thank you for having joined us. Assalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu alaikum wa rahmatullah. Jazakallah for having me.
You're welcome.